It was a point that he was trying to to make the process a little simpler. He was the one that had to explain exactly what took place.
No. A debate is a debate. You have a piloter of a motion, and then you have contributors that answer the argument.
So you think it was insulting on the part of the government?
It was not only insulting, it was grossly insulting.
If the law is good, and explain this to me, because you have admitted that Section 34 is good law, everyone seems to agree with it, then why all the fallout now? Why all the blame and why all the pointing of fingers?
Because the proclamation of Section 34 as a standalone section, Section 1 was proclaimed. That's the short title and commencement. Section 2 is the proclamation clause. Section 3.1 is the definitions clause. Section 32 is the clause which allows the Rules Committee of the judiciary to start drafting rules. And Section 34 is the one that allows what you call, it's a guillotine clause that cuts the operation of cases that have taken just too long. They've skipped out Section 33, which is that you will repeal the old act and that you will bring certain things into effect. Section 34 was specifically represented in the piloting of those debates in November as never seeing the light of day until the structure was in place, until masters were appointed. Who is going to consider this thing? Section 34 is drafted in the context of language which says the master shall do so and so. And the master is defined to be a criminal master. The criminal master has not been appointed. The rules amending the court system, the Supreme Court of Judicature Act, have not even been laid in Parliament to create those posts. So Section 34.1 can't even operate because there are no masters appointed under the system. So it is that absurdity that has caused this imbroglio. It is that absurdity. It is not that the law is wrong. We have a huge problem in our criminal justice system. We have hundreds of thousands of cases. You saw in the last year judiciary report, 104,000 cases brought to court. You see that the indictment system sees maybe 100 cases done a year. So you've got 100 cases in 100,000. You've got a huge backlog system going on. And creating the position of more judges or more masters doesn't solve it alone. You have got to say to yourself, there are some cases that are 25, 30, 35 years old.
Right.
We've got to cut the backlog out. And that's a hard decision, because you ultimately want people to face the criminal justice system. However, this country has got to use its time and resources carefully, and we have to have a proper system done. Now, I often complain in Parliament that the government does not take avail of proper resources. There is no white paper consultation, there's no green paper, there's no wider society. In this case of this act, the government came to court and said, listen, we've done the consultations. We have spoken to the Chief Justice, we've spoken to the Law Association, the Criminal Bar Association, we have spoken to the DPP on all of the terms of this clause, and it turned out to be untrue.
Is the problem premature implementation?
The problem is willful, deceitful, surreptitious, now nakedly unexplained action on the part of the government of Trinidad and Tobago. And if you are going to breach your word to the Parliament and people of Trinidad and Tobago, if you are going to misrepresent the truth of your position when you pilot a bill to the Parliament of Trinidad and Tobago, something has got to be psychologically and morally wrong with you if you do that, and you've got to explain it.
Senator, awaiting permission. Up to press time last night, permission had not yet been granted by the police to opposition leader Dr. Keith Rowley to march from the Red House to President's House today. Has permission been granted?
We're awaiting the permission, which I'm confident will arrive. Obviously, we cannot march in breach of the law. We must have permission to do so. And of course, we expect to receive that permission during the course of this morning.
If you do not receive that permission, what time is the march expected to commence?
The march, we will be assembling at the Red House for 1 o'clock. The march is intended to happen after that. But there is adequate time between now and then. I'm sure Minister Warner, who's watching this program, who says that he will make inquiries of the police, will do his very best to assist us in having this march, because I'm sure deep down he inside also wishes to put forward a responsible answer and not to say we're just moving on as the AG does, or there's a collective responsibility of the Parliament. I'm sure he doesn't really mean those things.
Senator, we have to take a very short break. When we come back, we will continue this discussion. Stay with us.
Making the transition from meltdown to recovery. Thursday, September 20 at the Trinidad Hilton. Speakers include Senator Dr. Rolf Balgobin, Senator Helen Drayton, Keith King, and other distinguished local experts. Making the transition. Thursday, September 20 at the Trinidad Hilton. For more information and registration, call 222-8928. Sponsored in part by Kuna Mutual Group, Blinkby Mobile.
Cheers, cheers, and more cheers. At Woodville Industries Limited, we offer a wide variety of top-quality chairs at very attractive prices for commercial and residential use. Come to Woodville Industries Limited, located at number 33B O'Mara Industrial Estate, Arima. Call or visit us today.
Power Master, this battery is it. This battery is power strong for the Caribbean and all around. Shipped to Europe and USA. This battery making headway. They call it the Power Master.
Visit any Power Master dealer, automotive components, the motorist, or Master Sale outlet and get cash back against the purchase of a new Power Master battery. Power Master gets you started.
The battery the world's after.
Get the news first. Read the Guardian newspaper anytime, anywhere, online. Take advantage of our special introductory offer of just $4.99 US per month and receive daily a digital replication of the printed newspapers as seen on newsstands. It's convenient and environmentally friendly. Act now. Log on to www.guardian.co.tt to sign up today. Get the Guardian e-edition now. We give you the power in your hands.
New Sunshine Snack Plantain Chips, hand-picked and sliced to perfection. You'll love the new tasty, delicious, crispy plantain chips. Sunshine Snacks, put a little sunshine in your day.
I love fresh salads.
I love the breakfast too.
I love the foot long. I love mine cut right through.
I love my Subway with all the fresh veggies.
Boom diada, boom diada, boom diada.
I love the healthy choice.
And then they're everywhere.
I love mine toasted quick.
And that they really care.
I love my Subway.
Prepare just how I say. Boom diada, boom diada, boom diada, boom diada.
Subway, eat fresh.
Senator, how would you respond to criticism that the judiciary agreed for the implementation of a new sufficiency scheme on January 2nd, 2012? The proclamation effected at that time, and we're referring to Section 34, the proclamation of that, was recognizing that the legal imperatives needed to be prepared for January 2nd. Do you accept that? And
yes,
is that the explanation?
I accept that. That's within their domain to speak. I can't speak to that. Let me explain or translate that. So the judiciary says this thing is going to come in January. However, the Attorney General and Minister of Justice, in their discussions with the Parliament, reminded us, let's get this thing passed and we will consider all of the aspects. Now, if this thing was coming in January and the DPP said to the Attorney General or to the Minister of Justice in the meetings, as the DPP says he has, the DPP says, look, for the first time when I saw Section 34, I realized that there were problems. I discussed it, and he says specifically in his press statement, and the Minister of Justice said Cabinet had made a decision. That's a very, can I use the expression, pregnant statement. It's pregnant because it's loaded with a whole lot more. The DPP says that. The Parliament then understands, well, hold on, what you told us about the DPP being aware of all of this stuff is untrue. The government would have been met with statements and opposition and advocacy and agitation on the part of not only the opposition of Trinidad and Tobago, the PNM, but several other sectors which would have said, listen to me, you've either got to amend your Schedule 6, which can easily be done by way of a minister's order and broaden it to take care of certain things, or you need to go back and relook at Section 34 before you implement it. We've had on the order paper of the Parliament the Land Adjudication Act, passed in the 1980s and never yet proclaimed, coming to Parliament to be amended by this government to fix something before proclamation. So the point is the misrepresentation that there was consultation and that the DPP had approved, and therefore the ramifications of this law were factored in particular by his department because he's in charge of prosecution of criminal cases. That turned out to be something that is of serious consequence. There was a misrepresentation of his consent and knowledge in relation to that position, and that would have resulted in an amendment to the law and a beefing of the schedule.
During the debate, the point was made over and over again that they spoke about the backlog of cases and that it allowed someone who's been waiting for that 10-year mark to come in contact with a judge to get this matter dealt with, that there's been a huge backlog of cases, that while the PNM didn't do anything while they were there, they are attempting to fix the judiciary, and they being the government. Okay, that argument is not only rubbish, but it is properly described as ad hominem. The PNM did nothing. Ad hominem, you're attacking your person's, your opponent's qualities or characteristics to make your point as a distraction point. That's properly ad hominem debate. And it couldn't be made over and over in the Senate because one person spoke. Well, it was made in the lower house. In the lower house. And I really don't have much regard for the people that spoke in the lower house opposite, quite frankly, in terms of the contributions that were made on that particular date. Because the fact is that the criminal justice system is something that had to have great consultation, and when you look at the record, you will see the specific reports in 2004 to the period 2008 by the criminal justice system members, and there was a massive amount of work done to get it ready. The Chief Justice has said that in his speech. He said that this thing can't be done. So it's not true to say that the PNM did nothing. The PNM had to do it in the correct course and timing. Senator, has the Parliament failed the people of Trinidad and Tobago? The Parliament, insofar as the executive drives the agenda and the executive makes representations, has failed the people of Trinidad and Tobago, specifically at the hands of the government then. So, you know the old system in computer technology, when you're learning computer sciences, garbage in, garbage out, GIGO. If you're going to put garbage into the system, you're going to get garbage out as your result. And most regretfully, the government's lack of a parliamentary legislative agenda, its lack of genuine consultation, which now everybody in Trinidad and Tobago must check. Every time a minister of government says, we had consultation, everybody's going to have to say, bring evidence of it signed off by parties.